Thank you so much, Maria and Mariana, for your introduction. And I'm, for those who don't know me already, Francesca Fanucci from ECNL. And let me say, first of all, that we are very happy and grateful to Daniel for accepting our invitation, because Daniel is not only the senior policy analyst and policy lead on emerging technologies at Access Now, but he's truly one of the most knowledgeable and passionate advocates I've had the pleasure to cooperate with. So thank you again for being with us. Now, as some of you may recall, in our webinar in September last year, we had a general discussion about the EU AI Act, which had just formally entered into force a month before in August. And we highlighted some of its most significant provisions. And it immediately turned out that one of the most embattled provisions was Article 5 of the Act, which introduces a ban for the sale and use in the EU of some AI systems that are already identified as presenting unacceptable risks to fundamental rights. So I would like to take this opportunity to break the ice by asking Daniel if he could give us an overview of these prohibited AI systems and why they are immediately identified as presenting unacceptable risks to fundamental rights. I give the floor to you, Daniel. Thank you.
Thanks a million to all of the organizers as well for inviting me here. And I can say exactly the same thing about Francesca, that she's one of the most passionate activists for human rights that I've encountered. And we've been doing activism on this topic for a long time, both in the EU AI Act and the Council of Europe as well. Just a couple of things to say before I talk is I'll say the word we a lot, and by we I don't just mean Access Now, I mean ECNL, EDRI, and a lot of other organizations that we worked with in coalition throughout the AI Act negotiation process. That included digital rights organizations, but also disability rights organizations, migrants' rights organizations. And any victories that we had were really down to the strength of that coalition, and as well to Sarah Chander, who used to be at EDRI and who's now at Equinox Racial Justice Initiative, who really coordinated that coalition. So it was very much a collective effort that is still ongoing. I'll also say I'm not a lawyer. Just so Francesca and anyone feel free to jump in. My background is in philosophy. I do my best, but if I say anything legally silly, please correct me. Yeah, I mean, I was thinking about how to answer this question first, because the actual language of the prohibitions is really complex. So I thought maybe first to sort of talk about them in a general way, which in what follows we'll see is maybe not reflective of what's actually banned. But when the AI Act, even before it came out, we as this coalition group did a lot of advocacy for prohibitions, because when we heard that a risk-based regulation was coming out, a lot of people were saying, yeah, but all risks can be mitigated. And this was why we pushed for this idea of unacceptable risk, because there are simply some risks that cannot be mitigated. And the distinction I always say is a difference between, when people in the mainstream discourse talk about the risks of AI, they usually talk about AI systems malfunctioning. So, oh, this system is biased, it's biased against Black people, for example, or women or something like that. And that is a huge problem, but there are AI systems that work perfectly and are completely incompatible with human rights when they do exactly what they're supposed to do. And that's really the type of systems that we're talking about here. So it's not about malfunction. It's like you're really doing what it says on the box. When the AI Act came out, thankfully there were prohibitions there. I believe there were 4 of them, and we advocated for many more, and we're very successful in the European Parliament adopting a lot of our positions. Unfortunately, that got watered down in the final act, but we do have a much broader range of prohibitions than the original one. So very broadly, we have the first prohibition prevents systems that use subliminal techniques or deliberately manipulative or deceptive techniques to impair someone's decision making and cause them harm. The second one is one that exploits systems that exploit vulnerabilities due to age, disability, or specific social or economic situation, again, to cause people harm. Then we have a prohibition that's generally called the prohibition on social scoring. And this was always a tricky one because it was a little bit of a prohibition of the thing that most people think happens in China, but maybe doesn't actually happen in China. So it was a bit of a problem with a lot of these prohibitions. There were some critics at the time said they were written to not actually ban anything, but give good sound bites to the European Commission. But, that has been modified a bit. And then I'll follow the order that's in the actual AI Act rather than the original. Then there's one on predictive policing, where AI systems are used to not predict who committed a crime in the past, but who would be likely to commit a crime in the future. So really pseudoscientific science fiction type rubbish that's extremely dangerous. Another one then to stop the creation of mass biometric databases from scraping on the internet. So you have two companies there, Clearview AI and PimEyes, who would be the most known ones who have these enormous databases of people's faces. Another one on emotion recognition in workplace and education institutions. The next one on biometric categorization systems that categorize people according to sensitive attributes such as race, political opinions, trade union membership, religious beliefs, sexual orientation. And then the big one that, as Francesca said, caused huge problems in the negotiations. And it was interesting because the AI Act first came out before ChatGPT was released, and that wasn't even a thing. And then it became the dominant thing in the media. But actually, this was the most controversial part of the AI Act, was a prohibition on what most people think of when they say facial recognition, and the technical word they use there is real-time remote biometric identification, because it can be done with your ear or your voice or other things besides face, and it's remote because it's at a distance. So it's not unlocking your phone, because it's not a distance question here, and it's also, yeah, that's authentication. We can get into the details if you want, but this is really when you have many people in a public space and then you're looking for one person or a handful of people in that mass. So it's really the kind of mass surveillance. So it sounds great, but there are problems.
Thank you very much for this outline, a very clear one. And on top of the problems in definitions as such, we know that we both know very well, unfortunately, that there were also exceptions that were introduced to these very same prohibitions that can be quite problematic for the protection of our rights and freedoms. So could you give us some examples of cases where these very prohibitions may be bypassed or circumvented courtesy of the AI Act?
Yeah, maybe I can give you an anecdote as well that might be useful for those of you who haven't been involved in the negotiations of a file. As I said, I'm not a lawyer, and when I started working for Access Now, I had to work on GDPR a lot, and certain things just didn't make sense to me. And for years, I always thought it was because I wasn't a lawyer. And eventually, I got confident enough to be like, oh, the law doesn't make sense. And now I understand why, having seen it, because you see the kind of, yeah, horse trading negotiations. Oh, you delete that word and we'll delete this one, and between the groups and the council and the commission. And then you end up with these things that don't make sense. And now we're in the position of having to interpret them. And so, to give you a very clear example of this, the prohibition on emotion recognition should have just been a prohibition on emotion recognition fully. In the parliament, there was even pushback against that. And what we got in the parliament's final position, so the position that they negotiated in the final negotiations, was a prohibition in emotion recognition in education, workplace, policing, and migration. I think you would all agree that policing and migration are the most dangerous ones there. And of course, they got removed in the final text because of the law enforcement lobby and migration authorities lobby. So there's no good reason for that. And it's funny because now you'll hear commission officials or someone talking about the AI Act and they try to justify that there's a good reason for that, but there isn't. It's lobbying. So we're dealing with the mess from lobbying and it doesn't make sense. So I think that's just good to keep in your mind. The other thing that's extremely silly in this one is emotion recognition can be difficult to define, but in general, what you're doing is you're inferring an emotional state from some observable feature. So technically facial configuration like a smile, and then you say the person is happy. But of course, I can smile because I'm angry. Like a psychopath is maybe going to attack someone and they're smiling. So it's not as simple. And actually, that's where all of the problem comes in, is this inference. And it was very clear in the definitions and everything that emotion recognition did not mean just tracking facial configurations. You can think of an avatar. If you wanted to have the avatar match an actor's face, then when I move my lips, the avatar should move the lips, but there's no inference to emotion there. So that's not emotion recognition. That's not covered. Also, fatigue detection for a driver, that if suddenly my eyes close, that's not emotion recognition. All of this was very clear. However, at the last minute, a very large European company decided to lobby and make them write in that there was an exception for medical and safety reasons. So there's an exception in the prohibition for medical and safety reasons in the workplace and education. And I just, if anyone can give an example of what that would be, please tell me, because it doesn't make any sense. Fatigue detection is already excluded, so it's not fatigue detection. What medical use do you have? And, we can talk about the guidelines in a bit, but this is the kind of nonsense where the different things don't make sense. On remote biometric identification, there were already exceptions in the original draft, and then Parliament, listened well and were pushing for a full ban on real-time remote biometric identification and retroactive or post identification. And the distinction there is that a system that, say is observing a town square and is immediately identifying if a suspect walks in, and then the police can then immediately engage, that's real time, versus post would be a crime happens and then they have an indication maybe the suspect was in this town square, and then they search to see if they could find that person and say, oh, this person was there last week. The distinction collapses a bit in the middle, but that's in broad strokes. We can talk about this, but there's no distinction in terms of the impact on rights there. And so based on that, we were arguing that both should be banned. Unfortunately, only real time is banned. And then there's three pretty big exceptions to that. So there's exceptions in all the other ones. And even, when there isn't outright loopholes that are the result of lobbying, there are very weird definitions or strange terms. The ones that I only read like a quarter of the text of some of the ones that I read out, and I'm just going to read it and just so you can hear what it is. But the first one, for example, the placing on the market, putting into service or use of an AI system that deploys subliminal techniques beyond a person's consciousness, or purposefully manipulative or deceptive techniques with the objective or the effect of materially distorting the behavior of a person or group of persons by appreciably impairing their ability to make an informed decision, thereby causing them to take a decision that they would not have otherwise taken in a manner that causes or is reasonably likely to cause that person, another person, or groups of persons significant harm. The reason I read that out is because if you want to escape that prohibition, every single word basically is another opportunity to argue that you don't fit the definition. They're so long, and they're not long because they're clarifying. They're long because they're trying to avoid things. And for a lobbyist, that's a dream. For a legal team, that's a dream. You can say, oh, okay, let's attack this word, this word, this word, this word. So the fact that they're so verbose and complex and use strange terms, that aren't sometimes even kind of terms of use within the context, means that there's a huge scope for loopholes.
Yes, and as you know very well, because I've been ranting a long time about it, on top of all these caveats, there is also the scope of the AI Act itself, which doesn't apply to issues of national security, for example. And then that has always made me wonder, does this mean that all these prohibitions will also fall flat if the member states just argue that they are using emotion recognition to protect national security? To what extent can you argue that it doesn't apply to what the AI Act doesn't cover? So that for me, it's very worrying, and we will live and see. But yes, as you mentioned, to make things further complicated, the European Commission recently published these guidelines, which are not yet formally approved, but which are not formally adopted, yes, but the Commission has approved them. And they are not a binding document, but somehow they try to shed a light on at least some of these prohibitions and how the states should implement them. So overall, do you think that they have strengthened the protection? Have they made more clarity? How do you think the states will take them on board, if they will take them on board?
Yeah, thanks. I mean, they're very long. For anyone who's opened them, they're 140 pages. Um, I I would say, I mean, a couple of high level comments about them. One is that I got very annoyed reading them because, as I mentioned before, like you have these silly wordings and exceptions that are there for no good reason. And now you have this whole apparatus of academic legal interpretation coming to justify them. And when you know why they're so bad and they don't make sense, it's quite jarring to see that like suddenly this is this big legalistic justification for something that is just doesn't make any sense. And that is strange. And what I would say to people who are thinking about, using these for activism on a national level or even on a European level is really feel free to disregard that sophisticated language that's coming up around them and, go to the core and trust your intuitions on these things. We had that experience with being involved in litigation in Brazil a few years ago around an emotion recognition system that, just cutting through all of the jargon and like really explaining what does the system do, what is the intention of the law, and like what, the spirit must be to protect people's rights and explaining it. And in that case, the judge agreed and said it just has to be the case that this was supposed to be prohibited under the law. And I think that there's scope there as well because, as I will keep saying, many of the things don't make sense. I it's important to note that, as Francesca said, the guidelines are non-binding, and paragraph 5 specifically says any authoritative interpretation of the AI Act may ultimately only be given by the Court of Justice of the European Union. And I think there's a lot of scope to, again, as a non-lawyer, to go to the Court of Justice to really undermine some of these exceptions and words. And in general, I was pleasantly surprised by how not terrible the guidelines are. I was expecting a lot worse. In some places they're quite good. I have problems with other bits of them, but I do think that those bits could really be can be challenged. There's tricky things where, for example, in the biometric categorization ban, there's a weird exception for police to filter data sets. So the ban is really about inferring these attributes from biometric data. And give you like a really crass example, this professor Mikhail Kozinski is well known for the AI gaydar. He claimed that he could infer sexual orientation from photos. And there's many reasons why the system he created is technical nonsense, and doesn't really make sense. But that's the type of thing that you're looking to ban here, where you're, inferring that someone is gay or something from the way they walk, the way they talk, or, political. He also claimed he could infer political orientation from people's faces. Real kind of eugenics type stuff. And then, for no understandable reason, there's an exception for police to filter data sets based on attributes. But that's not about inference. There's a big difference between inference and then filtering according to attributes that are already in a data set. So there's like real technical confusion between the two parts of the paragraph. And, having spoken to negotiators, it was very clear that they accepted that because it didn't actually talk about inference. But now the way that's being interpreted and presented by the Commission and the guidelines is that it does uh, allow that. So you see that like deals that were made during the negotiations are being interpreted very differently now by the people who made them. And so there's quite a lot at stake in the guidelines and in litigation, etc., to make sure that the interpretation is done as strictly as possible. But it can be very difficult because some of the words that sound technical, but they're not actually well established. Like we found this a lot, even on the remote biometric identification stuff, that there was no solid industry terminology that made sense from a technical perspective, and actually had to come up with our own stuff. Like Ella Jakubowska from EDRI did amazing work on trying to sort through all of that. So yeah, I would say it's not a disaster. There's some interesting clarifications. In parts, it's quite good, but there's a lot of work to do with this. And, even the guidelines themselves note that they will have to be updated or replaced as technical advancements are made.
Thank you. So let's say that if also through activism or litigation, civil society manages to achieve a clear-cut, let's say, interpretation, unequivocal interpretation of one of the prohibitions, and it is found that their state is violating this prohibition. So based exclusively, we know, for non-lawyers, I could say, the AI Act is a regulation, so in principle it's directly applicable to the states. Obviously, they may have to adopt further legislation to implement it, but let's say that these prohibitions are immediately applicable. So my question to you, Daniel, is that based on the AI Act, if a state is found in violation of a prohibition, so they do not implement the prohibition, what happens? Are they sanctioned? What are the consequences? And I would move on also to the subsequent question: how can activists in their own states hold their states accountable and ensure the correct implementation of these prohibitions?
Yeah, thanks for that. So in the guidelines, and I mean in the AI Act itself, you can see there's a section about penalties, about fines. Providers or deployers can be fined up to 35 million euro or up to 7% of global turnover. Member states, I think it gets a bit more common. There's EU institutions as well, obviously, like Europol, etc. But then there's national police forces. EU institutions, bodies, and agencies are subject to fines of up to 1.5 million euros, and member states have to determine that themselves per member state for public authorities and bodies. So I think, yeah, there's quite a bit of variation, but like with GDPR, DMA, everything, we're not actually interested in the fines. That's not the point. The point is to stop the practices. So I think that has to be, and it's complex as well, because I think um, if we're faced with a given system, we obviously want it to stop. But the point here as well is deterrent. We do actually want to stifle innovation. Despite what they all, I'm quite strong on this. I want to stifle some innovation. Because innovation is a neutral term. It's not good or bad. It just means new things. Some new things are bad. There's innovation in chemical weapons. There's innovation in surveillance. Let's stifle that and let's encourage socially beneficial innovation. It's a neutral term. So innovation in rights violating practices, I think should be stifled, and the fines, I do think, can do that. We saw, for example, a few years ago that a lot of companies were doing face-based emotion recognition, and then a lot of negative press came out about this, and they all switched to voice, which has the same effect on rights. But you do see that the market moves when there's bad press, when there's fines, etc. So yeah, like we definitely want to focus on stopping these systems, and that was really one of the main motivations, I think, in pushing for prohibitions in the first place, was to sort of flip the dynamic. The dynamic has typically been with AI that we don't even know that a system is in operation. We only find out that a system is in operation because multiple people are experiencing harms, and then maybe an investigative journalist or a whistleblower or someone brings to light the fact that an AI system is in operation. We get a basic look at it, and then it turns out that it was horribly discriminatory or just a complete disaster in the beginning. And that's really like after the fact, like the damage has already been done, like the Dutch child benefit scandal or something like that. With the prohibitions, you want to flip it around, and the idea would be, do not do these things in the first place. And yes, I mean, it's tricky as well because there's often a gap between what companies, if I want to be charitable, think they're doing and what they're actually doing, and uncharitable, what they say that they're doing and what they're actually doing. So it's not over, because we are going to have to chase them. To kind of segue into your second question, what will activists need to do with these prohibitions? I am pretty sure that the type of companies that would be developing the systems that fall under the bans are probably not going to um, voluntarily say that they're in scope. So there'll be all of this shifty stuff going on with how they market the products, saying that they fit the exception, or that they do sentiment analysis instead of emotion recognition, wordplay. I've seen this a lot in promotional materials. But what's interesting is, to get into the meat of the AI Act a little bit, is that the prohibitions are really a small part, and the bulk of the AI Act is about so-called high-risk AI systems. And in most cases, and the guidelines say this as well, if an AI system is within the general scope of one of the prohibitions, but it fits an exception, it's a high risk system. So it's not that it's like off the radar completely. And if a system is high risk, then it does enter into, yeah, as I said, the bulk of the AI Act, which is these accountability transparency measures. So in most cases, the system will be registered in the database. There's a publicly viewable database of high-risk AI systems that's listed in Articles 49 and 71. I can write them in the chat. It will come into scope of that, and then we would be able to see, oh, this system is on the market in the EU. In some cases, with public authorities, we'll be able to see where it's deployed. We could see some information about that. Unfortunately, more loopholes. Law enforcement and migration systems are now in a private, non-publicly viewable part of the database, which is extremely unfortunate. But, sorry for listing a lot of article numbers. There's another very interesting article, which is Article 77. And that basically says that national public authorities are bodies which are responsible for protecting fundamental rights, can have access to all documentation created under the AI Act. So, we've been discussing, and I think, Francesca, you've been discussing a lot with some of these bodies about how for example, national equality bodies or something could potentially get access to the documentation that's in the secret, the non-public part of the database. There's the fundamental rights impact assessments where they're applicable. So if I look at the litigation that we were involved in a few years ago and compare it to what should happen as the AI Act is implemented, so we were looking at this system that was being used in the Sao Paulo Metro, and the only thing that we could rely on were publicity, like promotional materials that we were able to download off their website. And we had to do a technical analysis based on promotional materials, which, they're not very reflective of the technical reality. Now, at least we should know that any system that falls within the scope of the AI Act should have done documentation A, B, C, D, E. It should be available here, even if it's not publicly accessible. This national equality body should be able to access it. Freedom of information requests. It gives us much more of a structured way to find out information about given systems. There's also then two rights. So in Articles 85 and 86, 85 is the right to lodge a complaint with the Market Surveillance Authority. So the Market Surveillance Authority is responsible for overseeing the prohibitions and making sure that they're not violated. And you can lodge a complaint, or an organization can lodge a natural or legal person can lodge a complaint. The right to explanation could be interesting and, builds on the GDPR a bit. But I was thinking that if you believe that you've been affected by decision-making based on an AI system and then you ask for an explanation, again, you could get more information to understand how the decision was made. And that could be enough to start litigation or something. Again, looking at the child benefit scandal, if an individual had done exercised this right, potentially they could have gotten information a bit quicker than how it actually played out. So I do think there's a lot of work for civil society organizations based in member states, organizations that do litigation, human rights bodies, etc., to kind of sit together and work out a few strategies of, okay, we can use this right, this transparency measure. And it's also very important, I think, to not overly focus on the AI Act, because if things are illegal under other legislation like the GDPR or Equality and Non-Discrimination Law, we could still use the apparatus of the AI Act to get more information about a given system, assuming that it uses AI. So, just because something isn't prohibited under the AI Act, it can still be illegal under GDPR. A lot of the work is already ongoing and the discussions have been happening, but they're definitely, as imperfect as the AI Act is, there does seem to be scope to work with it as the tool that it is. I think for Francesca and myself and others who were involved in the negotiation, it's a bit hard to move on from what it could have been, but still, it's there. Let's look at it and do what we can.
Thank you. Yes, indeed. And it's, when it came out, we were so underwhelmed by it. But now we see that the big lobbies continue trying watering down. So we realize that clearly there is potential still for us to make it stronger. And the very last question from my side before opening the floor to the questions from all of you is literally wants to focus on the potential practical case, since we've been talking about these prohibitions and potential cases, but moving on to a concrete example of these days that we have been discussing even internally at ECNL. As many of you probably are aware, Hungary recently passed legislation that gives the government the discretion to invoke, under the pretext of protecting children, they can restrict the right to protest, or at least in particular certain type of assemblies that are deemed to be damaging to children for some reason. So effectively, the pretext was that the upcoming Pride parades in the country, in which basically they are banned, and in order to implement this ban, the law authorizes police forces, law enforcement, to deploy facial recognition technology to identify the participants. Now, we have been wondering, in terms of attacking this law, if based on the prohibition included in the AI Act, could we argue that this use of AI system is already prohibited or not? And in any case, how can activists completely respond to this? Thank you.
Yeah, it's very tricky to question. I mean, short answer, I think it can be tackled under this or with some combination of different tools, but it causes me to do this many times when I'm like looking into it, because you see the damage that is done by all of the negotiation and the compromises that were made. If the Parliament position had been passed, this would be clearly, there'd be no way to justify this. But again, all of these little complications in the wording and stuff are, yeah, giving more scope for bad actors like Hungary to the Hungarian government to do this. I think, yeah, one of the issues, and I mean, if anyone knows more information about this, please jump in. I was off for quite a while, and it's one of the things I've been looking into since I've been back, but I was off when it actually happened. It seems to me that there's quite a bit of confusion about the extent to which it's real time or retroactive, and not really enough information there to decide. And both of them should be banned. As I said, there was always this argument that somehow the time delay made it less dangerous. And I always argued the opposite, that actually I think retroactive post remote biometric identification can be more dangerous. It can be used, for example, if a journalist leaks a story, it could be used to find their sources. So then you comb back through 2 years of footage, find out who they met, where they were, all of these things. And that's not live, that's the retroactive one. So there's absolutely no sense in which it's less dangerous. And in this case, I mean, to the individual activists, it doesn't matter if they're fined or arrested during the Pride parade or the day after or a week after. I mean, the effect on people's rights is the same. So unfortunately, the AI Act makes that distinction, which doesn't reflect the impact on rights. What I was wondering, and this is very much live discussion and improvisation rather than a clear answer, is to what extent it falls under the law enforcement directive. Now, I do not know enough about the specific implementation of the law enforcement directive in Hungary to answer this, but Article 10 of the law enforcement directive about the processing of special categories of personal data, as I understand it, there's 3 conditions that have to be met for it to be allowed. One is authorized by union or member state law. Okay, they have their new law. B, to protect the vital interests of the data subject or another natural person. I guess they're going to argue this thing about the children, which I would imagine should be defeated if it was brought to court. And C, where such processing relates to data which are manifestly made public by the data subject. That one is interesting because this is getting a bit into technicalities, but your face is not biometric data. Your face is your face, and biometric data is when you extract a mathematical template from a face. And so you see this in the definition of biometric data in the GDPR LED, is the result of a specific technical processing. That's biometric data. And so you would actually have to make the biometric template manifestly public rather than your face for them to be able to use it. And the EDPB have clarified this they did guidelines on facial recognition a couple of years ago. Off the top of my head, it was more, the question in the EDPB guidelines was about whether me putting photos of myself online constitutes me making my biometric data manifestly public, and they said it does not. So the Clearview AI or PimEyes or someone, they say they just index people's photos, but they don't. They index biometric templates extracted from photos. And so there is an important technical distinction there. I'm not sure how it plays out in terms of you being in public, but I think you could make a pretty solid argument that it would be the same thing. So based on the law enforcement directive, I see two ways to challenge it. But again, it depends a bit on the real time versus post, because if it's not real time and it's quite a bit of a delay, then I think unfortunately the AI Act doesn't come into play. But yeah, there's other options that we could use, and I mean, it's fundamentally discriminatory.
Yeah,
So
for many other reasons, you would argue that it is unacceptable, it is proportionate, and even the legitimate ground laughable. But yeah, we chose this as a typical case where it is even difficult to identify to what extent the AI Act is special law compared to the law enforcement directive, and the prohibitions apply to that case, to what extent you play around exactly the caveats. So just to show that there is a lot of damage that can be done, a lot of loopholes. At the same time, on the other hand, if you choose to see the glass half full, lots of opportunity to clarify and to reintroduce it as an unacceptable element. So thank you, Daniel, but I'm sure that there are questions waiting for you from everyone, even if I don't see them in the chat, but it's better if the people talk in person and introduce themselves. So I'm looking forward to it. Anyone that wants to break the ice?